Am I free to go?
I want my lawyer now.
I want a lawyer right now.
Mr. Nolan, it's for you. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Welcome back. You've heard it a million times on TV and in the movies. You have the right to remain silent. Lawyers like me tell people to shut the hell up. But very few people know how to remain silent. And really, there are just two ways to invoke your right to remain silent. The first, and the easiest, also raises some issues that we're going to get to. And that is invoking your right to remain silent by doing just that, remaining silent. Zip, say nothing. The issue with this is a Supreme Court case in 2010, Berghuis v. Thompkins, 560 U.S. 370. First, a little bit of background and understanding of the law here. Under U.S. law, and with very rare exceptions, people, whether they be criminal suspects, criminal defendants or not, have the right to remain silent. Look, it's part of your right not to incriminate yourself under the Fifth Amendment to the Constitution. Remaining silent is optional. You may speak or be as silent as you wish. The Miranda warning, which you've also heard for years on TV and in the movies, concerns the duty of the police or other formal questioners to make sure that the suspect, you, is aware that you have the right prior to questioning. Just in case you want to be silent or at some point, later you claim ignorance that you had the right to remain silent or that you had a right to an attorney and you would have relied upon that if you'd been aware of that. That's covered under Miranda v. Arizona, 384 U.S. 436. It's a 1966 case. And related cases contemplate that the suspect can invoke their rights, which is to say, make it clear that the person wishes to rely upon them, waive their rights, or make it clear that they do not wish to rely upon them. Now, a number of cases, such as Berghuis that we're talking about, refine Miranda by addressing when and at what point a suspect who is aware that they have a right to remain silent is said to have begun to rely upon that right, as opposed to when they were aware of the right, but were not choosing to rely upon it. Now, little known fact, hitting that like button has never been ruled inappropriate by the Supreme Court. And the YouTube judges make decisions based on likes and subscriptions, and smashing the hell out of that alert bell too. So go ahead and do that real quick. Here are the facts of Berghuis. And if you want to follow along, go to Oyez Cases 2009 08 1470. The link will be in the description. A Michigan state court convicted Van Chester Thompkins of first-degree murder, assault with intent to commit murder, and several firearms-related charges. After exhausting his remedies in Michigan State Court, Thompkins petitioned for habeas corpus relief in a Michigan Federal District Court. The District Court denied the petition. On appeal, Thompkins argued that his confession was obtained in violation of the Fifth Amendment. Now, that argument was that he was denied effective counsel as well at trial. The Sixth Circuit held that Michigan Supreme Court's finding that Thompkins waived his Fifth Amendment right was unreasonable because Thompkins refused to sign an acknowledgement that he'd been informed of his Miranda rights and rarely made eye contact with the officer throughout the 3-hour interview. It's like a 3-hour tour, only less fun. The Sixth Circuit also held that the Michigan Supreme Court improperly determined that Thompkins was not prejudiced by his counsel's failure to request a limiting instruction related to his separately tried co-defendant's testimony. Now, with Justice Anthony M. Kennedy writing for the majority, the court reasoned that Mr. Thompkins failed to invoke his Miranda rights to remain silent and to counsel because he had failed to do so unambiguously. Moreover, the court reasoned that Mr. Thompkins waived his Miranda right to remain silent when he knowingly and voluntarily made a statement to the police. After the Berghuis case, lawyers have to acknowledge that if you fail to unambiguously invoke your right to remain silent, then you have failed to invoke your right to remain silent. This becomes a major problem in light of Salinas v. Texas. The Salinas case held that your remaining silent can be used as evidence against you. Yeah, I said that right. Now you have the right to remain silent, but that silence can be used as proof of your guilt. This is why you must invoke your right to remain silent properly. Let's talk about Salinas. And again, you can follow along Oya's cases, 2012, 12-246. Again, the link is going to be in the description. In 1992, Houston police officers found 2 homicide victims. The investigation led officers to Giovivo Salinas. Salinas agreed to accompany the officers to the police station, where he was questioned for about an hour. Salinas was not under arrest at this time, and he had not been read his Miranda rights. Salinas answered every question until an officer asked whether the shotgun shells found at the scene of the crime would match the gun found in Salinas' home. According to the officer, Salinas remained silent and demonstrated signs of deception. I'm not sure what that is. A ballistics analysis later matched Salinas' gun with the casings at the scene. Police also found a witness who said Salinas admitted to killing the victims. In 1993, he was charged with the murders, but he could not be located. 15 years later, Salinas was finally captured. The first trial ended in a mistrial. At the second trial, the prosecution attempted to introduce evidence of Salinas' silence about the gun casings. Salinas objected, arguing that he could invoke his Fifth Amendment. Now that's saying he has protection against self-incrimination, whether he's in custody or not. The trial court admitted the evidence. Salinas was found guilty and ultimately sentenced to 20 years in prison and a $5,000 fine. Now the question is whether or not the Fifth Amendment's self-incrimination clause protects a defendant's refusal to answer questions asked by law enforcement before arrest and Miranda. Now, I can tell you the Supreme Court said no, you're not protected. Again, Salinas failed to properly invoke the right to remain silent, which brings us to the point of simply remaining silent while being questioned. That works if you actually remain silent after the arrest and Miranda, but not before arrest and Miranda. Then you still actually have to remain silent and say nothing. Most people are incapable of silence, and silence before arrest can actually be used against you. I promise you, police officers are aware of this decision. And this brings us to the second way to invoke the right to remain silent. You have to be clear and unambiguous. I do not answer questions without my attorney present. I want my attorney, and I'm invoking my right to remain silent. Yes, it is a mouthful. Yes, you'll be under a lot of stress and not likely to remember those exact words. Just remember the key points. I do not answer questions without my attorney, and I want my attorney, and I'm invoking my right to remain silent. There, see how easy it is? Practice it a few more times. Get ready. Practice it. After you say that, shut the hell up, or repeat that phrase after every question that's asked. Let's not take this to the extreme. If a police officer asks you if it's raining again after you walk into a building on an overcast, dreary day, he probably isn't investigating anything. He's most likely just human, and humans abhor silence, or he's curious about the weather. Don't take this to the extreme of being a dick to every cop you meet. Some of those will be dicks back, and on the street, theirs is bigger. You can beat the rap, you can't beat the ride. And in Missouri, it is not legal to resist an illegal arrest. So don't turn an innocuous comment on the weather into a charge for resisting arrest. To sum up, there are 2 ways to invoke your right to remain silent. The first, actually shutting up and not saying a word. Now that has potential issues, pre-arrest or pre-Miranda. The second is the only way that will be effective every time, provided you actually shut up. That is to say, I do not answer questions without my attorney. I want my attorney, and I'm invoking my right to remain silent. Then you will be quiet and contact an attorney as soon as you can. Or you can add to your statement by sporting one of our I Don't Answer Questions t-shirts. Thank you for watching. Don't forget to hit the like, subscribe, smash the alert bell, and we'll see you again soon.